Judge, and I am a lecturer here at UB in the Chinese Studies program. The topic of my presentation today is wartime erosion of International Criminal Court compliance. I'd like to begin the context of my presentation with a statement from the former Foreign Minister of South Africa, Naledi Pandor. She said, "What I felt the ICC prosecutor didn't answer me sufficiently on was, I asked him why he was unable to issue an arrest warrant for Mr. Putin while he is unable to do so for the Prime Minister of Israel. He could not answer the question." So what's happened now is a warrant was eventually issued for Prime Minister Netanyahu. And the premise of my presentation today is to try to answer the question of warrants for these political leaders who are leading their countries during wartime, and explain how compliance factors in, what states are doing, what they are expected to do, and then balance between a discussion of the legal implications and practical considerations. I won't go into all of these, but these are the members of the ICC. There are 124 state parties. So each of these territories is under the jurisdiction of the ICC. Non-state parties can be referred, or a jurisdiction can be declared by a UN Security Council resolution. The ICC is completely independent of the UN, and the Office of the Prosecutor is independent within the ICC. Unlike the ICJ, the ICC prosecutes individuals rather than states. The arrest warrant for Vladimir Putin centers around the war crime of unlawful deportation and unlawful transfer of Ukrainian children from occupied territory. Other warrants have been issued for the Commissioner of Children's Rights in Russia and Russian military commanders pictured there. The warrant for Benjamin Netanyahu was issued for the war crime of starvation as a method of warfare and intentionally directing attacks against the civilian population in the war in Gaza. A warrant was also issued for Yoav Gallant, the defense minister, and mind you, warrants were issued for the Hamas leadership. All of the Hamas warrantees were assassinated by Israel before they could be brought to trial. On the left-hand side of this table, we have parties that have signed and ratified the ICC Rome Statute. In the middle, we have signatories only, or former signatories, and in the final column, we have non-signatories. I won't go into all of these, and I will let it come out in the non-compliance incidents, but it is important to note that Ukraine signed in 2000 and ratified in 2024, and the Palestinian Authority ratified in 2015. Few countries have withdrawn from accession, including Russia and Israel. Hungary withdrew, and South Africa attempted to withdraw in 2017, but this process was not successful. It is a matter of precedent that political leaders guilty of crimes such as these are usually delivered by the home states themselves. Examples include Milosevic for the Yugoslav War Tribunal following the Srebrenica massacre. And most recently, last month, former President of the Philippines, Rodrigo Duterte, was delivered to The Hague. Now let us turn to incidents of non-compliance regarding the arrest warrant for Putin. The incidents of non-compliance have been divided between those that occur within or involve full state parties, and incidents that involve former signatories or signatories that have not ratified the Rome Statute. I won't go into the ones on the right-hand side, but there are 8 incidents of non-compliance to the Putin warrant. The one that was quite controversial in our area was the planned BRICS summit visit. Putin was the only founding leader of the BRICS that did not attend the summit in Johannesburg. The Democratic Alliance in South Africa filed a case, and the Gauteng High Court ruled that South Africa's government must publicly explain its legal position on whether it is obliged under international law to arrest Russian President Putin, and issued an order clarifying the obligation. The pursuant order revealed that the President of South Africa, Ramaphosa, actually corresponded with the ICC to request exemption under Article 97 of the Rome Statute. the visit was ultimately canceled by the Russian side. It could be in part because Vladimir Putin didn't feel confident that he could evade arrest by attending the summit, or because he was later dissuaded by South Africa's executive. But it's important to note that hypothetical airspace passage would have been preferable through 3 state parties. One route could have been the DRC, Zambia, and Botswana. And the other route could have been Kenya, Tanzania, and Malawi en route to South Africa. Or by the same token, if the Russian Air Force didn't want to take the risk, they could have just gone along the coast of the continent. The actual tangible incident that we have of non-compliance, however, involves Putin's state visit to the capital of Mongolia, Ulaanbaatar. On the 2nd of September 2024, as we will discuss, this incident of non-compliance was referred to the ICC by the Assembly of State Parties. It's a punitive measure for Mongolia. The other incident of note involves Brazil, which is another state party. There was another BRICS summit in Rio, and both Putin and Xi Jinping were not in attendance. An upcoming visit to another state party is due to take place in Tajikistan this month for a CIS summit. And again, it will be interesting to see how the matter is taken up by the ICC. Beyond that, we have many incidents of air transit in the case of Mongolia. There are several confirmed incidents of overflight and many unconfirmed incidents. And this is mainly because of Mongolia's geography. It is a landlocked country sharing international borders with Russia and China. And then, in the case of the Netanyahu visits, the most important non-compliance incident involves a state visit to Budapest, Hungary. Hungary was a full member of the ICC, and then in the aftermath of this visit, but while the visit took place, Hungary was still a member. Ultimately, Hungary deposited its instrument to withdraw from the Assembly of State Parties. The rest of the incidents involve now 4 working visits to the US, the most recent one being the visit to the UN General Assembly in New York City. And in order to get from Israel to the US, all of these countries allowed overflight. In the most recent incident, Netanyahu did not fly over France, and instead the flight was diverted very briefly through Spanish airspace over the Strait of Gibraltar. It was explained in the media that perhaps France didn't refuse the transit, but that Netanyahu decided not to use this route. There is another incident worth noting. There was a planned visit by Netanyahu to Azerbaijan, which is also not a state party to the ICC, but this visit would have required a minimum of transiting through Greece and Bulgaria, but also potentially Georgia, which is a state party. In the case of Turkey, however, it is not a state party. They refused to allow Netanyahu to fly over Turkish airspace for the visit. This brings me to my systematic index. I'm doing research. On the one hand, you have the most serious violations of the warrants within the jurisdictions that most readily apply. And you have 3 general options. You have heads of states, of state parties of the International Criminal Court, inviting 2 indicted war criminals to visit their countries. In the worst cases, there is an invitation and the visit goes ahead. This is hosting the war criminal, alleged war criminal. And then on the other hand, you have incidences of transit or overflight. No aircraft can fly in the sovereign airspace of a country without the government's consent. So de facto, these countries are allowing the free movement of indicted war criminals. The repercussions are most readily observable within states that are full state parties to the ICC. The most extreme action that can be taken is that the matter is referred to the ASP, and then the ASP will issue a statement. We haven't even got to the point where the ASP could issue some kind of substantive punitive measure or sanction. It hasn't got that far. As far as overflight is concerned, we actually don't have any examples of the court pursuing some kind of reprimand against the governments that allow overflight. There have been such statements among UN officials, UN special rapporteurs on human rights, but not the ICC itself. With that in mind, I felt it was fitting to compile this index and to arrange this index on the basis of whether a country is a full state party or a non-signatory. And there's a full penalty for state parties and then no penalty for non-signatories. So I have much more to say, and I believe I'm within time, but I can cut it down if needed. So I compiled all the incidences of non-compliance, and I found that Netanyahu's 4 visits to the U.S. lead to a score of 6, and Putin also visited the U.S. leading to a score of 7.5. Mongolia hosted Putin despite being a state party, and there have been several incidences of overflight which would cap the total score at 6. France has allowed the transit of Netanyahu 3 times, but also challenged the ICC jurisdiction in public statements. It was not tantamount to inviting Netanyahu to France, but the suggestion was made that if he visited France, because Israel is not a state party, that the visit would be allowed. Hungary hosted a visit by Netanyahu. They withdrew from the court, etc. So now I want to proceed to looking at a potential correlation with major challenges to the warrants. On the one hand, you have the score in the index, and on the other hand, you have actual challenges to the ICC. The greatest challenger to the ICC is perhaps Russia, because statements by Russian officials have been so extreme that they have insinuated launching a missile at the building in The Hague. Perhaps it was in jest, but this was a very significant person, a former president of Russia, Medvedev, who was making the statement. Russian authorities have also issued warrants for the prosecutor, Karim Khan, and several judges. These are career jurists, and if they step foot in Russia, they will be arrested. Israel obviously has disputed the warrants and filed various applications with the ICC. In the case of Mongolia, it was more of a drudging legal battle. In the case of Hungary, it was just more of a unilateral disregard for the court and then the subsequent withdrawal from being a state party. And then we have, I just wanted to mention the United States. Surprisingly, although not as extreme as Russia, the United States has engaged in many openly coercive tactics to attempt to get the ICC to drop the prosecution. There was a letter signed by 12 US senators threatening the court. It says that the United States will not tolerate politicized attacks by the ICC or our allies. Target Israel and we will target you. We will sanction your employees and associates and bar you and your family from the United States. You have been warned. And now there's sanctions proceedings that are managed by the Office of the Treasury. So these are my general conclusions. Number 1, the issue of overflight is highly relevant and should be considered going forward. We're talking about presidential aircraft here, which host nuclear response command centers and are flanked by 5th-generation fighter jets. Legal studies cannot possibly consider the practical ramifications of this kind of enforcement. Number 2, a state can be a prisoner of geography. It can also be dependent on the warrantee state economically. Take, for example, Mongolia. Number 3, a method such as the one I have laid out should be used to quantify compliance or non-compliance during this wartime period. Number 4, politically, we witness a gamut of challenges to the ICC, ranging from sanctions to disputation of jurisdiction and disqualification of judges. Number 5, enforcement is nearly impossible without state party cooperation, let alone signatories or non-signatories. And number 6, it's important to note that warrants issued by the ICC do have a tangible effect. They inconvenience and complicate the travel plans of the warrantees. They have to change their flight routes and paths, which itself has political ramifications for the peace processes and multilateral engagement. And finally, declaring the jurisdiction remains important because, as has been shown in the past, discontented home country populations may one day be the ones who eventually volunteer the indicted war criminals to stand trial and be brought to justice. Thank you very much, and I look forward to your questions and comments.
Thank you, Dr. George. We will now invite the next speaker, and that's Mr.